When I came in, your witness was by Zoom.
What?
When I came in, the witness was already on Zoom. So she's here.
Oh.
All right, they're going to bring the jurors in, and then I'll give them another break if this is everybody's last witness, because I'm waiting for the jury charge to come back down. And then it'll give you all a chance to look at it.
I know, probably want to take the witness on board iron. You want to do that now before we bring them in?
Why? Yeah, it needs to be done. Why y'all, everyone knew. All right, I consider myself to be very patient. Everyone knew this was the witness, and now I'm just being told you all want to take the witness on voir dire. All right, Diana, can you step in the hallway and tell Deputy Laura that the state wants to take this witness on voir dire? And Dr. Campos, if you could unmute for me, please.
Okay, can you hear me?
Yes, we can. Before the jurors come in, I'm going to put you under oath, and then the state may want to take you on voir dire very shortly. You ready? We're going to go back on the records. Defense, call your witness.
Defense calls Dr. Veronica Zamora Campos.
All right. And my understanding states you wish to take the witness on voir dire?
Yes, sir.
You may, before you proceed, is there any objections to the witness appearing by Zoom?
No, Your Honor.
Mr. Ruiz, do you have any objection to this witness appearing by Zoom? All right, state.
Doctor, tell me, where are you employed?
Excuse me?
Where are you employed?
Viva Pediatrics.
Okay, and did you have a patient by the name of Mercedes Latoya?
Yes,
When was she your patient?
she was my patient, effective, I saw her once on September 21st, 2017, out of her 7 provider visits.
Okay, and that was the only time that you saw her in office?
That is correct, for her 18-month well check.
Pass the witness.
Teresa Collins, Your Honor, doctor, excuse me. You're following the case, is that right, as a member of this practice?
Correct.
And the other 2 doctors that were here during that period are no longer with your practice, is that correct?
Yes, they're with another practice.
Now, in my subpoena to you, doctor, I requested a copy of the medical records. Obviously, you're not here today, but I did request them, is that correct?
Yes, you requested the records and we turned them in to you, yes.
You gave me records, yes, at some point. They weren't notarized, however, and so I can't put them in as evidence.
Oh, okay.
I just have a few questions.
Sure.
I'll pass the witness.
I have nothing further, Judge, and I'm gonna object to the relevance of this witness when she only saw Mercedes when she was 18 months.
All right, defense. The witness has stated that the only time they saw the child was one time in September 2017. What is the relevancy?
Relevance is she has access to the whole file. She's a treating physician in this practice, Your Honor.
All right, then someone needs to ask that question to make this relevant.
Dr. Zamora Campos, are you the treating physician for this child based on those records?
I am not the primary pediatrician. I did see her once, I did treat her once, yes.
But if you were to treat her again, and you can't because
Yes, 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 I would see her again, correct.
you would base what you were doing on previous records, is that correct?
That is correct.
That's the witness.
All right, so off the record, here's the court's point. She is saying that she's only seen the complainant once. That was September 2017.
Yes.
Is there anything else from this witness, be it other doctors in her practice who saw her, that goes beyond the date of September 2017? Because if she only saw her one time, September 2017, I need to know what the relevancy is.
Relevance is that she's the treating physician, that she goes by the whole record of the client in her office, and that that she knows what the child was treated for.
All right, we're on
Yeah.
the record. Ask the question, somebody ask a question where potentially this is relevant. Defense.
I'm saying it's relevant, Your Honor, to establish that the child was treated by this practice for the disease of asthma.
All right, then you want to make it relevant by asking her that question. I don't know if she treated her for asthma or not. That hasn't been presented.
Was your practice treating the child, although you hadn't, was your practice treating the child for asthma?
Yes,
Were you prescribing asthma medications?
the practice was prescribing asthma medication.
In your records, is there a section that indicates that you provided instructions on how to deal with asthma?
Yes, there is instructions in the record.
Thank you. Is that enough, Your Honor?
Yes, that's enough for the court.
Briefly, Judge, when was the last time she was seen by a doctor in your office?
April 23rd, 2021.
But we would still object to the relevance of this witness and also cumulative as it's been well established from two prior witnesses that were being set up.
All right, I'm going to allow the witness to testify. If you could bring the jurors in.
All rise for the jury.
All right, everyone, please be seated. All right, defense, call your witness.
Defense calls Dr. Veronica Zamora Campos.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you will provide will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. This witness is appearing by Zoom. State any objections to the witness appearing by Zoom.
No, Judge.
Defense, any objections to the witness appearing by Zoom?
No, Your Honor.
Mr. Ruiz, do you have any objection to this witness appearing by Zoom?
No, ma'am.
All right, if you'll state your name for the record, please.
Dr. Veronica Zamora Campos.
All right, defense is your witness, and please make sure everyone that you speak into the microphones.
Doctor, you're a pediatrician, right?
Yes, that's correct.
And are you a member of a practice?
Yes, I am.
How many doctors are there?
We have 4 providers.
Currently, when did you first treat Mercedes Lasoya?
I treated Mercedes on September 21, 2017.
Were you the first person to treat her?
That is correct.
And after that time, did you treat her or were other doctors in your practice treating her?
The other providers treated her.
If you were to treat Mercedes today, and you can't because she's dead, but if you were, would you be referring to those records before you? Child?
Yes, yes, I would.
Is that a common practice?
To refer to the record when we treat our patient? Yes.
Okay. Do your records indicate that there were appointments that the child did not show up for?
Yes.
Can you tell us which dates the child did not show up for appointments?
May 3rd, 2018. September 5th. No, correction. That's an error. November 15th, 2018, March 5th, 2019, July 9th, 2019, April 27th, 2020, August 11th, 2020, March 10th, 2021, and July 23rd, 2021.
Okay. Do your records indicate why the child did not show up?
I'm gonna object, calls for speculation and hearsay.
All right, if you know, you can answer the question.
No indication. No indication on the record why they did not show up.
Do you have a diagnosis in your records for the disease of asthma?
Yes,
And does it notice in your records when the child was first diagnosed with asthma?
her mother's history, August of 2017.
17, so. What was the regime that was recommended to the parent to care for the child with asthma?
In which visit?
Whenever, the first time, whenever she first got instructions on how to deal with the disease.
Oh, according to her. I believe it was her March 28, 2018 visit that she received instructions on wheezing, and her medications were initiated. So just I can't speak for the physician what they spoke verbally, but they gave her guidance on when to follow up in 1 month.
Did she show up for that visit in 1 month?
No, but she was rescheduled. She was rescheduled like 3 weeks later, 26 days to be exact.
Did she show up for that?
Yes, she did. She did show up at that visit, and then, but she usually had another reason for coming in. Hers was a hand, foot, mouth. She had gone to 1 moment. Oh, she'd gone to the ER. She had gone to Baptist ER for a rash.
Good job.
And that's when they gave her a breathing treatment. So yes, they discussed it at those 2 visits.
What kind of medications were prescribed, if any?
Albuterol, which is a bronchodilator, that was an inhaler, and a Flovent, which is an inhaled corticosteroid, as a preventative measure for asthma flare-ups.
Do you know if those prescriptions were filled?
No, I do not.
There is, if a child holds her breath with this condition, would that be a voluntary thing more than likely, or?
I'm gonna object, calls for speculation.
All right, you can ask your question, then the court will hear your objection.
Repeat the question.
If a child were to hold her breath with this condition, would it be a result of asthma or just bad temper or what? Can you say?
Unlikely for a 2-year-old to hold her breath willingly.
Are there any other specific maladies that Mercedes was diagnosed with?
Oh, when I saw her specifically, it was just her speech delay. That's throughout all her 7 provider visits. Most of them are well checks. Most of them are about her speech delays and getting referred out for early childhood intervention, speech therapy.
I noticed she missed an appointment in March of the following year when she'd have been 1 year old. Up to that point, did she have all her appropriate vaccinations and shots?
I'm gonna,
Yeah.
I'm sorry, doctor, I'm gonna object to relevance.
Sustained.
There's a diagnosis down there and recommend, not so much a diagnosis, but a recommendation that she received cardiovascular care. Which doctor recommended that?
Dr. Setlick. That was her last visit in the office, April 23rd, 2021.
Is there any indication that she followed up on that with a cardiologist?
We do not have records, but it's not uncommon for us not to receive the records from the specialist.
Did Dr. Settler describe why she was recommending cardiology treatment?
Because she heard a heart murmur on exam.
What does that really mean?
There's an extra sound between your heartbeats. So like lub dub, you're gonna have a sound in between or after. So it's an extra sound that we hear and we investigate it. Majority of them are benign, but as a rule, we try to be complete and refer to cardiology just to rule out any other problems.
You have no further information on your file, is that correct?
That is correct.
Yes, the witness.
State has no questions.
All right, is this witness excused?
Yes, Your Honor.
Yes, Judge.
All right, the rule has been invoked. What that means is you cannot discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state or the defense. Do you understand?
Yes, I do.
All right, thank you. You're excused.
Thank you.
Defense, call your next witness.
Rest and close, Your Honor.
All right, state, do you close?
State rest and close. Yes, Judge.
All right, and defense, you close.
Yes, Your Honor, rest and close.
All right, so ladies and gentlemen, this is all the evidence you're going to hear at this phase of the trial. What I'm going to do is I'm going to send you to the back. We still have a couple more things to work on the jury charge, and then I'll bring you back. Remember my previous instructions. All right, everyone, please rise for the jurors. Everyone, please be seated. She's just correcting a typo in the charge, and so I'll email it to you all.
Yes. They all got to them. They called them. Yeah. One. Oops. Which one counts? Five. And six. Okay. 40 and 41. I just got that. 40 and 41.
There.
Oh. Did you say brisket and when? My mic on, did you say brisket?
All right, thank you. All right, I appreciate it.
Thank you.
All right, and if there were a punishment phase, does everybody have their witnesses available?
Yes, sir.
Yes.
All right, George.
All right, everyone, please be seated. Ladies and gentlemen, I'm going to read to you what's entitled Charge of the Court. You do not have to memorize it. You'll have it back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant, Jose Ruiz, is charged in count 1 of the indictment with the offense of injury to a child alleged to have been committed on or about the 7th day of February 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 2 of the indictment with the offense of aggravated assault with a deadly weapon alleged to have been committed on or about the 28th day of January 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 3 of the indictment with the offense of injury to a child alleged to have been committed on or about the 21st day of January 2020 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 4 of the indictment with the offense of injury to a child alleged to have been committed on or about the 23rd day of January 2022 in Bexar County, Texas. Deputy Laura. The defendant, Jose Ruiz, is charged in count 5 of the indictment with the offense of injury to a child alleged to have been committed on or about the 1st day of February 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 6 of the indictment with the offense of injury to a child alleged to have been committed on or about the 2nd day of February 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 7 of the indictment with the offense of injury to a child alleged to have been committed on or about the 3rd day of February 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 8 of the indictment with the offense of injury to a child alleged to have been committed on or about the 5th day of February 2022 in Bexar County, Texas. To all of these offenses, the defendant has pleaded not guilty. 1, Our law provides that a person commits the offense of injury to a child if the person intentionally, knowingly, or recklessly, by act or by omission, causes to a child, 1, serious bodily injury, or 2, bodily injury. 2, an omission that causes serious bodily injury to a child is conduct constituting the offense of injury to a child if the actor has assumed care, custody, or control of the child. For purposes of an omission that causes serious bodily injury to a child, the actor has assumed care, custody, or control if the actor has by act, words, or course of conduct acted so as to cause a reasonable person to conclude that the actor has accepted responsibility for protection, food, shelter, or medical care for a child. 3, a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above, and the person uses or exhibits a deadly weapon during the commission of the assault. 4, child means a person 14 years of age or younger. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Omission means failure to act. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 6, the phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date, but the date of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by the statute of limitations. The statutory limitation period for the offense of injury to a child is 10 years from the 18th birthday of the victim of the offense. The statutory limitation period for the offense of aggravated assault is 2 years. The indictment in this case was filed on May 3rd, 2022. 7, our law provides a person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another for which he is criminally responsible, or by both. A person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Each party to an offense may be charged with commission of the offense. Mere presence alone will not make a person a party to an offense. 8, you are instructed that an accomplice witness, as the term is hereinafter used, means any person connected with the crime charged as a party thereto, and includes all persons who are connected with the crime as such parties by unlawful act or omission on their part, transpiring either before or during the time of the commission of the offense, and whether or not they were present and participated in the commission of the crime. You are instructed that a conviction cannot be had upon the testimony of an accomplice witness unless the jury first believes that the accomplice witness's testimony is true, and that it shows the defendant is guilty of the offense charged against him. And even then, you cannot convict the defendant unless the accomplice witness's testimony is corroborated by other evidence tending to connect the defendant with the offense charged. Such corroboration is not sufficient if it merely shows the commission of the offense. It must tend to connect the defendant with its commission. The witness, Katrina Mendoza, is an accomplice as a matter of law. If any offense or offenses was or were committed, and you are so instructed that you shall consider her as such and treat Katrina Mendoza as an accomplice. Therefore, you are instructed that you cannot convict the defendant, Jose Ruiz, on the testimony of Katrina Mendoza alone. You are instructed that the testimony of Katrina Mendoza must be corroborated by other evidence tending to connect the defendant with the offense committed. Moreover, you cannot convict the defendant upon the testimony of Katrina Mendoza unless you first believe that the portion of her testimony that ascribes guilt to the defendant is true and shows that the defendant is guilty as charged in the indictment. And then, as stated above, you cannot convict the defendant upon said testimony unless you further believe that there is other evidence in the case outside of the evidence of the said accomplice tending to connect the defendant with the offense committed. If you find that an offense was committed and the corroboration is not sufficient if it merely shows the commission of the offense, but it must tend to connect the defendant with its commission, and then from all of the evidence, you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against him. You are further instructed that you are required to agree unanimously on the evidence that you believe corroborates the testimony of Katrina Mendoza. You are further instructed that the state must prove the corroborating evidence beyond a reasonable doubt, and if they fail to do so, then you cannot consider that evidence as corroborating. 9, a person is criminally responsible if the result would not have occurred but for his conduct operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. Therefore, as to each count, you cannot find the defendant, Jose Ruiz, guilty unless you believe beyond a reasonable doubt that the injuries, if any, sustained by Mercedes Lozoya, if they were, would not have occurred but for the conduct of Jose Ruiz, either acting alone or together as a party with Katrina Mendoza. So that if you believe that the conduct of another person or persons alone was a concurrent cause sufficient to cause the alleged injury sustained by Mercedes Lozoya, and the conduct of Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, was clearly insufficient, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. 10, it is a defense to the prosecution for the offense of injury to a child that the act or omission consisted of emergency medical care administered in good faith and with reasonable care by a person not licensed in the healing arts. Therefore, with regards to the allegations in paragraph A of count 1, even if you unanimously find that the state has proven beyond a reasonable doubt that Jose Ruiz did intentionally or knowingly cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by a manner and means unknown to the grand jury, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, Jose Ruiz was administering emergency medical care in good faith and with reasonable care, then you will find in favor of Jose Ruiz on this defense. However, with regards to the allegations in paragraph A of count 1, if you unanimously find that the state has proven beyond a reasonable doubt that Jose Ruiz did intentionally or knowingly cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by a manner and means unknown to the grand jury, and you further find from the evidence beyond a reasonable doubt that at the time he did so, Jose Ruiz was not administering emergency medical care in good faith and with reasonable care, then you will find against Jose Ruiz on this defense. With regards to the allegations in count 3, even if you unanimously find that the state has proven beyond a reasonable doubt that Jose Ruiz did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with the hand of Jose Ruiz. But you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, Jose Ruiz was administering emergency medical care in good faith and with reasonable care, then you will find in favor of Jose Ruiz on this defense under count 3. However, with regards to the allegations in count 3, if you unanimously find that the state has proven beyond a reasonable doubt that Jose Ruiz did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with the hand of Jose Ruiz, and you further find from the evidence beyond a reasonable doubt that at the time he did so, Jose Ruiz was not administering emergency medical care in good faith and with reasonable care, then you will find against Jose Ruiz on this defense under count 3. 11, count 1, paragraph A. If you believe from the evidence beyond a reasonable doubt that on or about the 7th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by a manner and means unknown to the grand jury, and you find beyond a reasonable doubt that the defense of reasonable emergency medical care as instructed in paragraph 10 does not apply, or paragraph B, if you believe from the evidence beyond a reasonable doubt that on or about the 7th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by omission cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, and Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, had assumed care, custody, or control of Mercedes Lozoya and failed to do so, and that Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, failed to seek adequate medical treatment for Mercedes Lozoya, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 1 of the indictment, and do not consider paragraph 12. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 1 of the indictment, say by your verdict not guilty of the charged offense of injury to a child in count 1, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 1 as instructed in paragraph 12. 12, count 1, lesser included offense, paragraph A. If you believe from the evidence beyond a reasonable doubt that on or about the 7th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by act cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by a manner and means unknown to the grand jury, and you find beyond a reasonable doubt that the defense of reasonable emergency medical care as instructed in paragraph 10 does not apply, or paragraph B, if you believe from the evidence beyond a reasonable doubt that on or about the 7th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by omission cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, and Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, had assumed care, custody, or control of Mercedes Lozoya and failed to do so, and that Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, failed to seek adequate medical treatment for Mercedes Lozoya, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 1. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 1. 13, count 2. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 28th day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did use or exhibit a deadly weapon, namely his hand, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally, knowingly, or recklessly cause bodily injury to Mercedes Lozoya by covering the mouth and nose of Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant, Jose Ruiz, guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment. 14, count 3. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 21st day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with the hand of Jose Ruiz, and you find beyond a reasonable doubt that the defense of reasonable emergency medical care as instructed in paragraph 10 does not apply, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 3 of the indictment, and do not consider paragraph 15. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 3 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 3, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 3 as instructed in paragraph 15. 15, count 3, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 21st day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with the hand of Jose Ruiz, and you find beyond a reasonable doubt that the defense of reasonable emergency medical care, as instructed in paragraph 10, does not apply, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 3. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 3. 16, count 4. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 23rd day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by pinching Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 4 of the indictment and not consider paragraph 17. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 4 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 4, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 4 as instructed in paragraph 17. 17, count 4, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 23rd day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by pinching Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 4. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 4. 18, count 5. Now, if you believe from the evidence beyond a reasonable doubt that on or about the first day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by inserting tacks into the feet of Mercedes Lozoya, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 5 of the indictment, and do not consider paragraph 19. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 5 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 5. And next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 5 as instructed in paragraph 19. 19, count 5, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the first day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by inserting tacks into the feet of Mercedes Lozoya, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 5. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 5. 20, count 6. Now, if you believe from the evidence beyond a reasonable doubt that on or about the second day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with a belt, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 6 of the indictment, and do not consider paragraph 21. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 6 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 6. And next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 6 as instructed in paragraph 21. 21, count 6, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the second day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with a belt, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 6. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 6. Count 22. I'm sorry, number 22, count 7. Now, if you believe from the evidence beyond a reasonable doubt that on or about the third day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by pulling the hair of Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 7 of the indictment, and do not consider paragraph 23. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 7 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 7, And next, consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 7 as instructed in paragraph 23. 23, count 7, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 3rd day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by pulling the hair of Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 7. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 7. Number 24, count 8. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 5th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with a cell phone, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 8 of the indictment, and do not consider paragraph 25. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 8 of the indictment, say by your verdict not guilty of the charged offense of injury to a child in count 8, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 8 as instructed in paragraph 25. 25, count 8, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 5th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with a cell phone, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 8. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 8. You are instructed that your verdict in each count must be unanimous. If there's evidence presented of more than one alleged instance that could constitute an offense committed by the defendant against the complainant, if any, you are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense in each of the individual counts. Evidence of any other alleged acts of misconduct by the defendant against the complainant in this case is not to be considered unless you believe those acts, if any, were committed beyond a reasonable doubt. With regard to those other acts, if any, you are instructed that said evidence was admitted, if it was, only for the purpose of showing the state of mind of the defendant and the complainant in the previous and subsequent relationship between the defendant and the complainant, if it does, and for no other purpose. You are instructed that under our law, that no evidence obtained by an officer or other person in violation of any provision of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe or have a reasonable doubt that the evidence was obtained in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America, in such event, the jury shall disregard any such evidence so obtained. Our law provides a defendant may testify on his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you're instructed that you cannot and must not allude or refer to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item, or evidence or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt. Gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. it is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty of the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. Before we begin, could I have parties approach, please? And state, my understanding off the record in discussion with the defense, you decided to reserve your time for rebuttal.
Yes, that's correct, Judge.
All right, Ms. Conley, are you prepared to proceed?
Yes, Your Honor. Good afternoon. First of all, I apologize for the drama on Friday. And for the minor drama on jury selection when I became disoriented. Did recover from that one, but Friday was a disaster and I apologize for it. What I'm asking you to consider, first of all, what if Jose wasn't home that day? Would he be in that chair right now? I think it's an interesting point. Mercedes is dead. Mercedes, precious Mercedes Lasoya, 5-year-old child, is dead. How did she die? The state's not worried about that. They're just worried about what happened before she died. There are plenty of charges. I won't go into all of them. I don't want to drive you crazy. You've been here long enough. I am most deeply influenced by Jordan. She had a front row seat to everything that happened. Maybe she was asleep sometimes. Basically, she was there. I don't believe she had an opportunity to be coached. She gave her statement to a social worker, apparently the day after her sister was found dead. And the testimony she gave was that her mother was jamming food into her sister's mouth. Her sister was spitting it out. She kept jamming it in. And ultimately, she shoved a spoon down Mercedes' throat. At that point, Mercedes fell on the floor, according to Jordan, and she had no more breath. Jordan said that her mom tried to put breath in Mercedes, but it didn't work. I believe she said it happened twice, but it didn't work. Mercedes had no more breath. My recollection is that Jordan then said, my mom took me and Mercedes, and we went to her boyfriend's apartment somewhere in the complex. Mercedes had an opportunity to say, oh, Jose brought her back to life when we got to his place. She never said that. As far as she was concerned, her sister was dead when they left Jeanette's apartment. And they were in Jeanette's apartment. They weren't in Jose's apartment. Who is Jeanette? You never saw her. State never brought her. But she was there. She had been the place where Katrina had stayed with her children for 2 days before her death. Katrina told you that. Now, I'm telling you things that I saw, my perceptions, my beliefs. You are not required to listen to me. I'm required to tell you what I think and to hope you'll go the direction that I'm trying to put you in. But you don't have to. You are the final determiner of what is truthful and what you've just seen for the past week. What did CPS, Child Protective Services, do to protect Mercedes? His name is not called Jose Protective Services. The name of the agency is Child Protective Services. Did you hear anything that indicated that they protected Mercedes? Anything at all? I would suggest to you that you didn't. You heard a very fine man, Mr. Adame, report on what he saw as an investigator, but you didn't hear any testimony about, well, we're CPS and we did this or that. To my knowledge, you didn't see it. Again, it's your information, it's your beliefs that count, not what any lawyer tells you. And then there's the police. We had, I believe, 3 neighbors that testified that they called the police because they heard a child crying in agony, not just moaning and groaning because she didn't have a toy, but crying in pain. They heard they heard hits, they heard smacks. They called the police. With the witness Mo, as I recall, they didn't show up. With the other witness, the couple, the woman said they did come to the upstairs apartment, but they didn't go inside, to the best of her knowledge. They just stayed outside. I didn't hear any follow-up. It's up to you. Did you hear any follow-up by SAPD? Now, I'm not telling you that that cop should have broken in the door. In the present climate, he'd probably have been arrested if he had broken in the door. But could have followed up with somebody from his department the next day looking into, was the child all right? You didn't hear any evidence whatsoever that anybody checked up on Mercedes. There was another time that that neighbor called, as I recall, and she said that there was no response at all. In both cases, that neighbor was not contacted apparently by anybody to follow up on the story about whether the child was safe or not. Ultimately, that's really what we're talking about in this whole case. Who protected the child? The state has submitted Katrina Mendoza, the co-defendant, as the witness against Jose. Technically, there, in my opinion, only 3 people, pardon me, that would have the information on what actually happened: Katrina, Jose, and Jordan. The judge has instructed you cannot rely completely on the testimony or evidence produced by the accomplice. And I ask you, what was produced, except what Jordan said, other than by the accomplice? I would say everything. Everything came in from her. Was she believable? That's your decision, not mine. She called her daughter a liar. She said Jordan didn't really see her shoving food down the child's mouth. Jordan didn't really see her put a spoon in her mouth. Jordan didn't really see her fall to the floor. And Jordan didn't really see her stop breathing. Jordan never used the word stop breathing. Again, what I'm saying to you is what I recall. I'm not trying to mislead you. Your statements, your thoughts and remembrance may be different than mine. It's you that count. Can't say that enough. She also said that reports from police and whatnot were wrong. An interesting thing I thought about Katrina's testimony was her memory that sometimes was crystal clear, And other times, she couldn't remember anything. She only had 2 kids. She couldn't remember what schools they went to. She couldn't remember what medicines they got. She couldn't really recognize asthma and that's a serious disease in her child. She said, as I recall, that it wasn't very serious asthma. Who do you believe, Jordan or her mother? We have the detectives, Size and Detective Warren Size and Detective Cahill, who gave an extremely expert analysis of what they had seen. They were horrified, understandably. But they were, I believe, flawless in what they did in terms of investigation. Gustavo Cervantes was the charge nurse, as I remember him to be. He didn't see Katrina run into the hospital carrying Mercedes saying, "Help my baby," but he heard it. According to the charge nurse, she had no life in her. She was cold. She had no signs of life. They tried to resuscitate her. I think it was 3 times that they had to do it under the Glasgow rules or something, but they couldn't resuscitate her. They put an instrument in her knee and various other places to try to get blood and put IVs in, but they weren't successful. At that point, we have Katrina, I believe, feigning an emotional situation. Detective Cahill didn't believe her at all. He thought she was faking emotion at the time. And this was right away. This wasn't days later, it was right away. If you're carrying your child into an ER, you have to fake it. If she's not breathing, again, your call. I suggest to you that if you believe, and I don't know what you're going to believe, so I'm covering different angles of this, but if you believe that Mercedes was alive when Jose saw her and that he gave her resuscitation, and I believe he said held her over his shoulder like a baby, patting her, trying to clear her lungs. If you believe that, and if you believe he acted carefully and reasonably, that's a defense. It's a defense by the statute. It's not a defense by Teresa. It's a defense by the statute.
Your Honor, I'm going to object to a misstatement of the law.
All right, ladies and gentlemen, the law will be given to you in the charge of the court. You may continue. And 5 minutes, counsel.
Thank you. When you look at your charge, it will explain probably in better language than I just used because I didn't have it memorized. But if you feel that that part really did happen and that she didn't come there dead, then you find him not guilty. Katrina is going to get a benefit out of her testimony. She could get probation, which is the other term for deferred adjudication. The most she can get in jail, the most under her plea agreement, is 45 years. She can get anywhere up to 45 years. Over 5, it has to be minimum 5, but anywhere up to 45 years. What if she did such a good job and you convict Jose of all this stuff? What if she gets 10? What if she gets probation?
Object to relevance, Your Honor.
All right, that'll be overruled. Ladies and gentlemen, this is closing arguments. You may proceed.
Thank you. My final words to you. Nobody protected that child, that beautiful little child. She was alive. Nobody vindicated her death. It's up to you to do that.
Right, state.
Thank you, Your Honor. May it please the court? Adjourned. Mercedes Lozoya was 5 years old. She was a 5-year-old little girl. Now, unfortunately, everyone except Katrina that you saw in this trial only knew her from February 7th, 2022 and on. They can only describe her as bruised, missing hair, missing toenails, missing teeth, horrifically injured. So what do we know about her? We get from the little details. We know that the neighbors would hear her talking back. You can tell from that picture she loved her sister. She was a fighter. As Detective Lloyd said, she was a second born. Discipline. Discipline is what Katrina called it. She needed more discipline, so she went to Jose. He said, hey, give her to me. I'll show her discipline. Well, discipline was abuse. But what Jose did took it to a whole other level. That abuse became cruelty. Plain cruelty, torture. And this case has been emotional. It has been trying. It's important. Down to the technicalities. Jury deliberations, you are to select a foreman, go through the evidence. I think we have 111 exhibits. Not everything is in evidence. It's important to understand the police reports. Things that we referred to but didn't actually admit are not going to go back there, but you'll have multiple videos, Jordan's statements, defendants' statements. That charge is enormous. It took us 45 minutes to read it. Don't get lost in the weeds. Don't overthink it. On or about, this is one of the ways that people sometimes get lost. On or about is just that. You'll see a date range from the counts. They're January 23rd, 2022, all the way to February 5th. On or about simply means before the date of indictment. I know that sounds silly, but legally that's all it has to be. Do not get stuck on that. It's been proven. Now, count one, injury to a child causing serious bodily injury. You all do not have to agree how the serious bodily injury occurred exactly. Only that Jose Ruiz was the cause, acting with Katrina Mendoza. You can say that manner and means unknown. We know he hit her. We know he made her hold heavy things, but we don't know exactly what led to the serious bodily injury. Or paragraph B, failing to seek care. Count two, we have an aggravated assault with a deadly weapon, and counts 3 to 8 are injury to a child with bodily injury. Manner and means, you must be unanimous that the actions of the defendant and co-defendant, Katrina Mendoza, as a party, resulted in serious bodily injury to Mercedes. Our serious bodily injury is not one, obviously she has bruises all over her. She's covered in bruises. All of those bruises, either by themselves or in conjunction with the horrendous exertion that they put on this little girl, led to rhabdomyolysis, rhabdo, which led to kidney failure. And you heard that that is a substantial risk of death. And one thing defense counsel said, I'm going to repeat again, we're not here how she died. That day, that horrible day, when for some reason this defendant chose to go from northeast side of town, ignore all the hospitals up there, and drive all the way to Southwest General. We're not here to talk about how she died on that day. We know she had rhabdomyolysis, and we know that she had injuries covering her body. That injury is enough. Law of parties. If you think Katrina Mendoza is the one who did all of these things, but you think that they acted together. Remember, Katrina was the one who invited him to use physical discipline on her. Katrina was the one who would spank her, have him hold her down. They did it together until it got to be a little too much for Katrina. Care, custody, and control. He took custody of Mercedes on January 21st, 2022. We know that even before that, the neighbors overheard Mercedes screaming, "Dad, no." So they called him Dad. They were under his authority. They were under his roof. He assumed care, custody, and control of that child. Like I said, rhabdomyolysis equals death if it is not treated. It is serious bodily injury. Gustavo Cervantes, Dr. Molina, Dr. Cannon all said that. Permanent disfigurement. You look at her. You look at her and see if she had permanent disfigurement. Protracted loss of a body member or organ. Her kidney was failed. Ag assault, deadly weapon. This is referring to the multiple times when Jose would put his hand over her mouth and over her nose. Yes, Katrina Mendoza talked about it, but you have to think too, Katrina Mendoza, as guilty as she is for her part in this, what she said was corroborated by stuff that Jordan said, corroborated by Jose's own cell phone, corroborated by the neighbors who clearly said that Jose, the man, was the one making those pounding noises. Injury to a child, count 3. Striking with the hand. I'm asking you, go back there, that horrible video of them in the car, that was only one of 3 from that day. Go watch those videos. See him hit her. Look at those rings. All of these pictures are in evidence. Look at those rings. Look at the injuries. Or read the medical examiner report. You'll see multiple punctate injuries of 2 to 3 centimeters. They match up to his rings. You see his fingers in the pictures there from when he knocked out her teeth. Injury to a child, pinching with the hand. He actually admitted to this in his statement. He admitted to pinching. This was the first injury that Katrina Mendoza said she saw after that first day. Inserting tacks in the feet of Mercedes. That was from his phone, from when he would watch her on a Ring camera. And that diagram right there is from the medical examiner's report. All of those are holes in the bottom of her feet. Count number 6, striking her with a belt. Jordan and Katrina both talked about it. Pulling her hair. I don't need to show you those pictures again. You remember. She had huge chunks of hair missing. Jordan, Jose, and Katrina, they all pulled her hair, but mostly Jose. Striking Mercedes with the phone. Now, both of her hands were horribly bruised and injured, and that was from his phone. We had Detective Knox, who we put in the timestamps of the exhibits, and then Katrina came and we gave you the pictures that corresponded it. I'm putting them together here. January 21st, 2022. This is the day that he took Mercedes. This is the day, for some weird reason, he decides to start filming what he's doing to her. 4:44 p.m. She's holding that jug. 5:20, she's got an injury on her lip. 6:54 p.m. is the last of 3 videos where he's forcing her to do this, forcing her under threat, hitting her. Also note, her teeth are intact. January 21st, her teeth are intact, her hair is intact. The only injury you can see on her face is the one that he had just caused. January 22nd, he starts putting urine-soaked underwear in her mouth and filming it. January 25th, her hair January 31st, 7:21 a.m., he sees her on the Ring video. Maybe she wasn't supposed to be standing up. I don't know why he got mad. But 6 minutes later, you have the picture, and I cut out part of it. It's that horrible picture where she is bound and she is on the floor and she is naked.
5 minutes.
7:28 a.m., there is another shot. We did not enter it into evidence because it was so awful. Up like a crucifix, naked with clothes over her face. All within 7 minutes of each other. February 2nd, 2022, he covers her in bandages, takes a picture of it. February 4th, there goes her tooth. February 5th, Katrina told you this was her final straw. After this is when she finally took the girls and left. Look at her face. In such a short amount of time, she went from smiling to looking distressed. She was sick by this point. She had been overworked. She had been overworked to the point where her body was giving out. Now we know in Bexar County, Texas, the defendant, Jose Ruiz, on or about February 2022, did intentionally or knowingly cause serious bodily injury to Mercedes Lozoya, a child, a 5-year-old child, by manner and means unknown. And what we mean by that is that you get to decide. Was it that time that he had her up like this? Was it the time he made her hold the jug? Was it the countless beatings? Or was it a combination? And that gets you to guilty. Beyond a reasonable doubt, it's not defined in Texas, not required that we prove guilt beyond all doubt. You use your reason and your common sense.
3 minutes.
We know that's a picture of a gun. It's missing some pieces. We don't know everything. We don't know why he filmed it. We don't know why Katrina didn't leave sooner. We don't know everything, but we know that he hit that little girl again and again. And that little girl cried out for help. And unfortunately, she didn't get that help. But we're not here. CPS is not on trial. Police are not on trial. Jose Ruiz is on trial. Do not lose sight of that. That man knew exactly what he was doing. You don't hit a 5-year-old child and not recognize the danger in that, especially someone like Mercedes. Listen to his statement. She was fine. She was fine. She was fine. No, she wasn't. She was dying because of the serious bodily injury that he had given her with those beatings and that overwork. Now, you might have been wondering, why did we go through so much effort to give you that jail call? It didn't play very loud in court, so I wanted to end on it so that you know that he knew exactly that he caused those injuries to Mercedes. If that autopsy comes back while I'm in jail, I'm staying in jail. Because he knew what he did. This is not a reckless act. You don't do things repeatedly, recklessly. There's lesser included offenses. No. He hit that girl. He overworked that girl. Him and Katrina worked together in making that little girl's life hell the last 2 weeks. And we ask, just like defense said, let's vindicate her. Please find Jose Ruiz guilty of all counts. Thank you.
All right, ladies and gentlemen, I'm going to ask for you to remain defense and state, if you'll meet me over here, please.
Oh.